Hello, I'm Gwen Gamble, and I'm here to welcome you to the fall term of Sunriver U's classes. Today's class is the first in a three-part series on legacy and retirement planning. Sarah Subius from the law office of Watkinson Laird Rubenstein will be our presenter. Her topic is estate planning, the critical step of naming your fiduciaries. During the question and answer time, she'll be joined by one of her partners, Jane Yates. Thank you very much and enjoy the class.
Absolutely perfect. Thank you for the introduction. And yes, so I do estate planning and administration. So both sides of the table when I'm working with families to plan for an estate, but also to administer the estate after someone has passed. So I've got trying to give out examples today. Hopefully that'll help because like Gwen said, this is somewhat of a study in language and terminology because there's a lot of different concepts, a lot of different pieces to this. But hopefully we'll get through it and leave it open for questions at the end. And same disclaimer, I am an attorney. My job is to take facts and apply the law and give advice, and I can't do that in a group setting. So please, keep questions general and I'll do my best to answer them. But I can't take a specific scenario and apply the law to it and give you advice. So that's my big disclaimer. My second big disclaimer is I am at my home office today and I've got two less than 1.5-year-old dogs behind me. So if there's barking or squeaking, I think you might have just heard a squeaker toy. Those are not my coworkers. Well, they're my fuzzy coworkers, but anyway, there we go. So disclaimer, there may be some dog sounds in the background. So yes, why did I think it would be fun and interesting and important to do a whole presentation just on fiduciaries as an estate planning, not about assets, not about, will contests, all the things we could talk about. Why is it important to talk about fiduciaries? It's important because ultimately for each of you, when you're doing your estate planning, it's about who has the authority and the duty to help out in all of these roles. It's not just about where do your assets go, but it's about who's helping you or who are you a nominated fiduciary to help. So a fiduciary is just a fancy word to say it's someone who has an obligation to do something for somebody else. They have a duty to do their best to help somebody else out in a role. So it's just a relationship from one person to another. So the handout that I put together, there's 2 pages to it, and that was intentional. The first page is lifetime fiduciaries. When I said, we need to talk about who's taking care of you, that's a lifetime role. The second page then are administration fiduciaries, different options for who takes care of an estate after someone has died. But lifetime fiduciaries really, to me, is the key towards making sure that you're avoiding harm, you're avoiding complexity, and you're making things smooth and transitions as everybody ages, or as your parents are aging or other family members need assistance. You might be called to act in one of these roles, and you will hopefully be asking others to step into these roles for you. So starting at the top, for people who will need assistance making legal or financial decisions. So what would that look like? That could look like entering into a contract. You have been in the hospital and now you're going to a rehabilitation facility. There we go. And somebody needs to sign the admittance paperwork. It's not a medical decision, but it's somebody contracting on behalf of you saying that you would be willing to make those payments. That could be a legal and financial power of attorney. A power of attorney is when you grant to somebody else the right to make legal and financial decisions for you. That person is obligated to make them for your benefit. They can't make them for their own benefit. They can't make a deal that benefits them over you. If they accept their role as your power of attorney, they have to make decisions that will be to your betterment. A legal and financial power of attorney is probably the key tool in all of lifetime fiduciary planning. It avoids the harm of you ending in a position where you can't make your own legal and financial decisions. You become incapacitated. you can no longer have the ability to make those decisions for you. If you haven't granted someone the right under a power of attorney, then the only other way someone can get that right to make legal and financial decisions for you is to go to the court to get a court-appointed conservator. And someone can, ask to be that conservator, but they have to go through the court process of asking the court to be the conservator, show why you need that conservatorship, and then also have someone come out and interview. Excuse me, I think we have some little growling here. But have somebody come out to interview all the parties involved to say, is a conservatorship needed? And are you the right person, or is that the right person to be that conservator? It's an involved process with the court. There we go. Okay, so the court would decide if that person or if you are the right fit to be a conservator, and then you would have legal and financial authority over another person. The second set of fiduciaries here for lifetime fiduciaries is control over assets. So control over somebody else's assets. The first one, again, is the power of attorney. If you have a power of attorney and someone has an asset, you would be able to act on that asset for them. For example, you need to sell a house and you are out of town, hopefully doing something fun. Your power of attorney, if this is acting on your behalf, can sign to sell your house if that asset is in your name. Very often people use the power of attorney to pay bills. Somebody's become incapacitated, they become hospitalized, something has happened, but someone else has a power of attorney to walk in and keep the bills getting paid out of that person's bank account. Another way to have control over someone's assets is if you have contributed your assets into a trust. And in this case, I'm talking about a revocable trust, a living trust, sometimes it's called. And in that case, if your assets have been contributed into a trust, but you are no longer able to manage your assets as the trustee of that trust, the trustee is always the person with the legal authority over trust assets, you can nominate a successor trustee, a backup trustee, to step in when you can't do it for yourself. So someone else could step in with legal authority over your assets that are held in your trust, again, to take care of them for your benefit, to pay bills, to sell the house, whatever needs to happen. But to do that, to have that role work, you would need to have set up a revocable trust during your lifetime. The third piece then for control over assets is, again, that conservatorship, the court-appointed conservator role. That conservator, once appointed by the court, would have the ability to manage your assets. But again, it's a court process, it's an expensive process, it has annual reporting requirements to the court, it's a public process. All of that means that it could be avoided had you had a power of attorney in place and or a revocable trust with a trustee named to manage your assets. Let's switch gears a little bit for the third fiduciary role, and that is making medical decisions. So in Oregon, if you are capable of making your own medical decisions, you make them. So we're talking about not someone making them when you could, but only making them when you can no longer make your own decisions. And the easiest way to do that is to nominate what's called a healthcare representative. And in Oregon, we do that under the Oregon Advance Directive. It's a form, it's kind of complicated, it's getting longer each time they revise it, but it's a form that allows you to name your healthcare representative, make life decisions about life support and tube feeding in a variety of end-of-life scenarios. And the new form that's just coming out actually next week, it allows you to give your wishes and values, what's important to you, a lot of good information for your healthcare representative to know about when making your healthcare decisions. So the Oregon Advance Directive, at a minimum, you can Google it, you can go find one. It's got to be that Oregon form. It's a very specific form to Oregon, but that's what most physicians are used to looking at to find who have you named to make your medical decisions when you can no longer make them for yourself. And I want to pause here. There's one more that is not on this form because it's not something that is a fiduciary, but it's a little bit of confusion sometimes. A POLST, I think it's called the Practitioner's Order for Life-Sustaining Treatment, or a DNR, do not resuscitate. This is that pink or orange form that some folks have attached to their refrigerator that tells EMTs and others coming in their house whether or not to resuscitate. That's different than the Oregon Advance Directive. The Oregon Advance Directive is a form that's filled out by you personally, and it's either witnessed or notarized, and then you name your healthcare representative. The POLST is actually filled out by a medical provider, and they put the order on there to do not resuscitate if that's the appropriate thing to do. So back to the outline. If you have not named a healthcare representative, and if you don't have a POLST or something else that has specific instructions, and there's no one to make your medical decisions, the hospitals have a default rule about who they can talk to for medical decisions. But if those people aren't available, a court-appointed guardian would be the next level to get someone in place to make your healthcare decisions, ongoing healthcare decisions. As with the conservatorship, somebody applies to be the guardian. They get court approval only after an investigation by what's called a court visitor to go talk to all the parties to find out, is a guardianship appropriate? And is this person the right person to be the guardian? And if so, the court has literally taken away your ability to make your own healthcare decisions and substituted somebody else's decisions in your place. If they appoint somebody you don't want, that's not a good result. And that result can be avoided by getting in front of it and appointing a healthcare representative. I will say that all these roles, that person needs to be willing to act on your behalf, but definitely in the healthcare representative role, each person you've asked to act in that role has to accept their appointment ahead of time. Can't spring it on them. They have to accept ahead of time that they're willing to take that job on. Okay, and then the final piece on lifetime fiduciaries in Oregon is the piece that you can't really, you can give nominations for your guardian, you can give nominations for your conservator. If these things happen, this is who I want, but ultimately the court is going to decide. Your nomination carries weight, but the court's going to look at who those people are at the time, and if they don't feel they're suitable, they won't give them the authority to be your guardian or conservator. The important point that I want to bring up is neither a power of attorney nor a guardian, nor a conservator, nor your healthcare representative decides whether to move you out of your home and into a care facility, for example. The decisions about your residence over your objection. And this is one that comes up a lot, and it's sort of a gap in between all of these roles, is that in order to have you, over your objection, move into a facility or to move residences, only a court-appointed guardian can do that, because the court has literally removed your ability to make those decisions and substituted someone else's judgment for you. Power of attorney can't do that. Healthcare representative can't do that. Okay. So I'm sure we'll have lots of questions when we get there, but I'll take a pause and move to the second page of the handout, which is estate administration fiduciaries. Again, it's somebody acting on someone else's behalf, but here we've changed who we're acting on their behalf, because during your lifetime, I would name somebody to be my power of attorney. I would name somebody to be my trustee or somebody to be my healthcare representative. But in death time, suddenly I'm not around anymore. So who is that person acting for? That person, that fiduciary role, is now acting on behalf of all the people or organizations who would receive your estate, receive the assets from your estate. So it switches from being me naming somebody to take care of me to me naming someone to carry on my wishes as I've directed under a will, a revocable trust, or according to the rules of the state of Oregon. So again, this is the state administration fiduciaries. If someone dies without a will, without a revocable trust, And an asset is in one person's name alone. Nobody has legal authority over this asset. Let's take the bank account. And that bank account has one owner, no beneficiary. We have nobody that has legal authority to deal with that asset after the owner has died. If a person had a bank account and is in that situation, there is a process called an intestate, it's a fun word, intestate estate administration. And basically, it's a probate administration through the probate court, which there's one in every county, that sets the rules of the probate administration based on the default rules for the state of Oregon. So let me unpack that a little bit. Under the rules of Oregon law, if someone doesn't have a will and there's an asset that needs to have someone manage it for purposes of administration after that owner has died, the state of Oregon sets the rules for who's in charge of the estate, who is the personal representative or estate administrator, depending on the context, for that estate to take care of those assets. And it's who you would expect. It's, priority is given to a spouse, children. If there's no children, they look up to parents, siblings, and that's who gets the authority. But it's broader than that too. If you owed somebody money at your death, your creditors could also be estate administrators and open up a probate estate to get paid from the assets of your estate. So your estate administrator, is a fiduciary for purposes of administering your estate through an Oregon probate according to the rules of the state of Oregon. And that person is going to be approved by the probate court. So if you've got a couple different people that are racing to the courthouse to try to get appointed as an estate administrator, the court ultimately decides who's the right person, who has the most authority and the priority to be put into that role. The second role then is very similar, and that's the personal representative of an estate. Same idea that we're talking about a probate administration. We're talking about putting a probate administration through the court. There's an asset that has one person's name who's died, no beneficiary. Then the personal representative named in the will gets priority to be in charge of the estate. Again, though, the court has to approve it. So you would have the personal representative submit the will to the court and say, "Dear court, here's the will. The will is valid, hopefully, and it names me as personal representative." And then the court reviews it. People can object. That person can be named the personal representative of the probate estate. So again, that person's job isn't to take care of you, is to fulfill your wishes as directed under the will that gets admitted to the probate court. Finally, then, the last estate administration role I want to talk about is the trustee of a revocable trust. So remember back up during lifetime, we said that you can transfer your assets into a living trust or a revocable trust and be the trustee, or you can hand that job off to somebody else to be the trustee, but you are still the beneficiary of that trust. You are still the one who gets the priority for the assets and it's supposed to take care of you. Well, at your death then, as the person who was the beneficiary, the trust changes. Now those people you've named in the trust to receive your estate become the beneficiaries of the trust, and your trustee's job is not to take care of you. Your trustee's job is to take care of the assets for the benefit of your beneficiaries. Again, you name that person ahead of time. You name that person to step in without having to have court supervision because you've already retitled your assets. You transferred assets into this trust during your lifetime. So it's all three of these roles. I will say a few general comments. During your lifetime, you want the person who understands you, who absolutely trust, who's going to do a good job to take care of you in the way you know they can, how you expect, and to understand what kind of decisions you would make and your values and priorities. An estate administration fiduciary is a little bit different. This person now is suddenly working for the benefit of this whole other group of people. Sometimes what I see as a estate planning attorney is that we will have different people in different roles, depending on whether it's a lifetime fiduciary or for estate administration. Lifetime fiduciary could be one of a number of children, right? Could have one child who you're closer to and would step into that role, or a sibling, or somebody else that is closer to you and you will be able to take care of you in a way that you appreciate. Estate administration, though, can be different. Suddenly that person works for a whole different group of beneficiaries, as I mentioned. So I've seen it that instead of having that person continue on to be the estate administration fiduciary, instead you've got a different person. You've got maybe a neutral person, somebody who's not going to receive assets into the estate, somebody who's actually maybe a professional trustee who does this for a living and is not the person who has to act for the benefit of all these other people. So it's worth thinking about, what is each person's job? What are they going to be tasked to do? And who are they serving in these roles to see who's a good fit? It may not be that one of your children, or if you're a sibling with some others, that's the right person to take care of everyone else's estate, because that puts it, in some ways, it puts a target on their back, right? They become the person that everybody looks to make sure they're doing a good job managing the estate, to make sure they're doing a good job of accounting for all of their transactions and getting to where they need to be. It could be that, it's the right person for lifetime roles and for administration roles, but it's not always the right person. Again, why it's critical to look at these jobs to say, do I have the right people in the right jobs? Have I got all of their authority in place ahead of time so that they can do legal and financial decisions for me? They can help manage my assets. And also, do I have somebody lined up to make medical decisions for me? And in all of these roles, if they're available, having one or two named persons, with a backup plan to make sure that if that go-to person isn't available, there's somebody else that you trust that would do a good job in that role, already named and able to step in if your first priority isn't going to do the job for you, or wants to back out for some reason. So that's kind of the big picture of this. It's like anything else, the ounce of prevention and the pound of cure, equation about getting ahead of setting up your fiduciaries for success, putting the right people in the right roles to do a good job for you, and conversely then do a good job for the beneficiaries of your estate who will receive your estate, to make sure they're the right person to step in and do the job of an estate administration. Couple other thoughts before we go to questions. One is, I've alluded to this a little bit. There are people out there whose job it is to be a professional fiduciary. You've got bank trust departments. You've got trust companies that's what they do. They're licensed and bonded to manage trusts. You've got other folks who are licensed and bonded to be professional fiduciaries without a big bank behind them. And maybe they're going to be more nimble and more helpful to help in that power of attorney role, to help in a medical decision maker role. But there are folks out there that can do that. So I see a lot of people naming friends or family members that maybe aren't a great fit for that role because they don't know who else is out there that could help them. There are professionals available. They charge for it, of course, but they would be the neutral person, the person who, knows how to do the role and would be able to take care of both life and death time administration. Well, maybe that's a good time to pause and go. So Gwen, I'm kind of wrapping up on my end here. I probably, or hopefully not, but probably have some questions out there that I would love to field. I see some folks are popping on. So let's go to questions. I'll see how we do.
Okay, I'm going to start by admitting somebody in the waiting room here. I think he tried admitting, and then we'll get him on and muted. There are some questions, and I'm going to invite Jan Yates to join us. Jan Yates is the local attorney for your office, correct?
Yes, Jane is there in Sun River.
There she is.
No worries. Yeah, Jane is there. Her focus, she does a lot of real property business work. That's more of her focus. But as an attorney and as part of a firm that we are, we back each other up in everything. So Jane definitely speaks this language as well, because especially like I've said a couple of times, when you have a fiduciary selling a piece of property or a fiduciary managing something, even a fiduciary managing a business, it's all connected. We have to know how these roles work and make sure that we've got folks in these roles. So Jane speaks fiduciary. How's that?
Very good. All right. So we have our first question. It's related back to the power of attorney. And can you limit what the power of attorney has control over, such as, can you say you can pay my bills but not sell my house?
Yes, absolutely. And I'm going to run down a little bit of a rabbit hole on that one, because there's all kinds of versions of all of this, because it's nothing can be that simple. So yes, the answer is yes, you can. There's typically what's called a general power of attorney, and that's saying if I can do it, my agent can do it for me, right? That's no limitations. But even under a general power of attorney, you can have restrictions. You put in the document, nope, this person can't do that. Versus the other end of the spectrum, you can say, I have a power of attorney to Jane Yates solely for the purpose of, I don't know, training my dog or something like that, taking my dogs to dog training class. You can limit the scope of your power of attorney to be as broad or as narrow as you want. And you need to make sure the document reflects that.
Okay. Another question is of the medical decisions in healthcare. So what happens to your advance directive if you happen to be in another state or another country when you have a medical issue?
Yes. Oh, that's a great question. My hope is that if you have it with you, that it's going to be respected by these other states. We have the ability to, within, the states, respect each other's forms. It may be, the medical provider may be kind of trying to figure out exactly what it says and how it works, because they're going to be used to a different form. But all of these forms should be respected in other states. Other countries, I can't comment. I don't know how it would work in other countries. But one would hope that if you have a document that shows what your medical priorities are, that the medical providers there would respect that.
Okay. Another question with the medical decisions. You mentioned that in like the next few months, Oregon is going to update the advanced directive form. If you currently hold an advanced directive, do you need to redo it as Oregon updates its process?
You do not. You do not. If you have an existing, fully executed advanced directive, it stays in force. It's only if you were to do a new one, you would want to get the most recent form to use.
Okay. And please, everybody, if you have a question, just type it to Sunriver U in the chat feature, and I'm happy to address those questions to Sarah and Jane. All right. How about hiring a professional fiduciary? Does that happen often? And do you have a kind of a ballpark figure on how you go about doing that?
That is literally the $1 million question. I'm just kidding. Yeah. So they, like everything else, there's different versions of this. If you hire a bank trust department, for example, you've got, pick a bank that has a trust department, Wells Fargo, Bank of America, or a professional trust company. Typically, they're going to charge for the value of the assets in the trust themselves. So you would say probably at a maximum, you'd be looking about 1% of the value of the trust would be their annual fee. And they're going to have their own fee schedule, and you can probably find those online. But that's kind of a good working ballpark for a trust company. As the value of the trust goes up, the percentage goes down so that they're not taking an unreasonable amount. Other independent fiduciaries, like when I'm thinking of folks who are independent businesses of people who act in these roles, they might charge hourly. And then their pay scale is going to depend on what they include. Like if they do tax returns and accountings and all these other more complicated tasks, they're going to charge more because they're, supplanting maybe an accountant and some other roles. But if they're merely a project manager, they may charge less, but then have other professionals that they hire to do the job as well. So it really depends on who you're hiring. But my advice, if you're thinking about professional trust company, is absolutely to reach out to different folks and talk to them and find out what their typical charges are, get a hold of their current, fee schedule, and then talk about their best process for getting them on board for your plan. A lot of them will want to know ahead of time that they've been named, even if they're named as a backup, so that they have you and your records in their file and know to kind of keep tabs on, do they need to step in? So they take their job seriously. Yep, they charge for it, but you're gonna have a professional step in to be able to do that work and hopefully do it well.
Okay, thank you. If you have a living trust, after several decades, you die, the lawyer's retired, the law office closed. Is there a problem?
Oh, yes. If a trust falls in the forest and no one has a copy of it, does it still make a sound?
Trust? Yeah.
Yeah. It's yes. And this actually happens sometimes. You find a piece of real property, right? Somebody's got a piece of real property in a trust and no one can locate the trust. Or you've got, life insurance policy in the trust. So it happens. Unfortunately, not that often, not as often as you'd expect. But thankfully, the court is available for trusts as well as wills to have somebody come forward and say, we can't find a copy of the trust. We found this. This is what we think. Give notice to everybody who might be involved as an heir of that person, and do the best you can. So sometimes it's the art of just trying to make some assumptions, give everybody notice to make sure that you're not missing anything, and then move forward.
Okay. The next is an efficiency question. Ooh. After someone dies, if you have only one person named to take care of everything involved in your settlement for others after death, is it more efficient? Or what steps can you do to make it more efficient?
Yes. Yes, it's more efficient. Having one person sign everything, perfect, harmony of information, because that person knows everything that's going on. It's definitely more efficient from an administration perspective. Having that person know about things ahead of time, know where assets are located, know where documents are located, have a sense of what's going on. Some of the efficiency really are just conversations, conversations with folks who you've asked to do different roles so that they can do it very efficiently. But then when that person starts to do the administration, them having the information, them being act alone is much more efficient. Sometimes we think of good reasons to name co-fiduciaries if one person maybe is out of the country, or other considerations mean that efficiency is lost, but there's some other factor that's gained.
Okay. We're going to jump back to the institutional fiduciaries.
Right.
Do institutional fiduciaries have a minimum value threshold?
Almost, well, if you're talking to an institution, yes. Almost all of them who are attached to a bank or a trust company will have a minimum amount, because they have, by their fee schedules, typically they have a minimum charge, right? There's a minimum amount that they say, we have to charge this in order for you to, for us to be able to take on this work. And to do that, you have to have a minimum size of the trust to make it that amount they charge isn't unreasonably big, right? If you have a $5,000 minimum charge and you have a $50,000 trust value, that's unreasonable. It's a huge amount of the trust that would be taken up in fees. So for a institutional fiduciary, yes, you're gonna run into those. But for a person or an independent person who's going to charge at an hourly rate or some other type of rate that's not based on assets under management, no, usually they wouldn't have that.
Okay. Okay, a question about trust. You've used the phrase revocable trust. And what's the difference between a revocable trust and an irrevocable trust?
Yes, yes, yes. So a revocable trust is in a nutshell, it's kind of a will substitute, but also a lifetime asset management tool. So it's revocable. You can revoke it, you can change it, you can amend it. It's merely a tool that we use to give asset management to a trustee, which can be yourself, which can be another person during your lifetime. And it then becomes irrevocable, can't be changed, can't be amended, either by its own terms or when the person who created the trust died. During someone's lifetime, they can set up an irrevocable trust, but as that term seems to indicate, you can't revoke it, you can't change it without a whole lot of legal work to get things either changed or get everybody to agree. So irrevocable, you set it up, it's there, it's going to stay. Revocable is a will substitute and a way to have others help manage your assets.
Okay, but you said a revocable trust changes to irrevocable after death?
Yeah.
Okay.
Yeah, because at that point, you're not around to change it. So it would be in.
But your named person can't change it either.
Exactly, right, because your trustee is then working for the benefit of the beneficiaries you've named. They're no longer helping you out. They've switched to their duty runs to those trust beneficiaries.
Okay, so the phrases or the words, will and trust, are they redundant or complementary?
They are different creatures.
Okay.
Yeah. A trust is a relationship between a trustee and a beneficiary to do the things that the trustee is supposed to do for the benefit of the beneficiary, like manage assets. A will is the document that guides the probate administration to say, how do these assets get distributed?
Okay.
And
I know it's a whole new
distinctions too between a probate administration and a trust administration. And I don't do a lot of estate planning, so Sarah, anytime you want to jump in, go for it. But generally, a trust administration, that all happens privately. A court doesn't have to get involved or anything. The trustee disperses the funds according to what your wishes were and everything. It's more efficient. It's more work ahead of time to set it up. But once you pass away, it's easier to administrate. Where if you just have a will, then the personal representative gets appointed and has to operate under the auspices of the court, do regular reporting, have things approved, have final accounting approved, and it's all a matter of public record. So when I've got clients who have closely held businesses and a lot of assets, they typically want to maintain some sort of privacy. And then one of the ways that they can do that is by doing a trust instead of having a will, because one of the things that you do in the will is you have an inventory and it gets filed with the court. So anybody can go down to the courthouse and see, you know, what your investment accounts are, what your interests in companies are, all of those sorts of things.
Okay. So you were talking about the difference there between a will and a trust. Are there some good general guidelines that help us decide if we need the will or a trust, which route you go? Or
Yes. So I would say there's a few factors that to me are sort of, you need a trust, right? And this is, you know, my personal opinion after doing this for many years, but really, and Jane also appreciates the word efficiency. We like efficiency, and trust administration is much more efficient because you don't have to do sometimes extra reporting, like Jane mentioned. You don't have to do these extra steps that the court requires if you don't want to. So you definitely would want to trust if you have real property in more than one state. If you own a home in Sunriver and you own a home in Arizona, you would have a probate administration in both Oregon and Arizona. You don't want, that's very, very inefficient. If you, like Jane said, if you have businesses or other assets that you don't want people to know about and that privacy is a concern, the trust is going to be private. A big one that is kind of a sneaky one is under, back to the idea of privacy, under a probate administration, there are two groups of people who get notice of the administration. The first group is those people you've named in your will. So I've named these people to take my estate. They're named, they get notice of the probate because they're named. But in Oregon, and this is Oregon specific, also your intestate heirs get notice of a probate administration. So if I decided to cut my daughters out, they're 9 and 7, so right, jury's still out on that. But if I decided to cut my daughters out of my estate and give it all to Humane Society or something, if I used a will, my daughters are going to get notice of the probate. They're going to get a copy of my will, and they're going to know what's going on. And for some folks, they don't want that. Especially I've seen with folks who don't have children, or if they have a second marriage and things get complicated. Everybody gets notice of the probate if they would otherwise take the estate if there were no will. So that one is kind of a sneaky one that jumps out, not as often. Usually it's property in multiple states, a big concern for privacy, but that concern for privacy also meaning who gets notice of your estate.
Okay, that was a very meaty question.
Yes.
Lots of good information. So at this point, I don't have any other questions coming in today. I'm going to give everybody, oh, there we go. Oh, it sounds like somebody said, is it good to have a will and a trust?
Yes, yes. Thank you, whoever said that question. Yes, if you have a revocable trust, 99.9% of the time, you want to also have a will. And typically your will is what's called, and I don't know why it's called this, but it's called a pour over will, as if you're pouring something over. And the idea is that in the event you have tucked away all of your assets into this trust, but an asset is still outside of the trust at your death that has to go through probate, or if probate is initiated because there's some litigation going on, somebody's fighting about something, anything that goes through probate, then your pour over will says, okay, close the probate, put it into the trust. So it goes into that private administration of the trust. Everything gets consolidated for the trust administration. So yes, you want to have the will as the backup plan, because a successful administration with a trust is you have a will that you never need to use.
So if you put things in a trust, do you have complete control over it until you die, assuming you don't have the power of attorney situation for paying bills and medical issues?
Yeah, so you as the trustee, right? I put a trust together for my benefit. I am the trustee. I have complete control. If I become incapacitated and I resign and name Jane as my successor trustee, now she has control to pay my bills and do all those things she needs to do for me. But I still retain control of the trust in that I can change my trust to get rid of Jane as my successor trustee if I still have capacity to do so and she's not doing a good job.
Okay, so I think in our, dare I say, television world of what is needed for our own legal coverage, I think the word will gets used a lot.
Yep.
And maybe the word trust is a better thing to consider. I mean,
it is. And I'll say the one thing that drives me absolutely crazy, and you see it all over the internet, is people say a will avoids probate. Full stop, wrong. Absolutely wrong. A will, the whole design of the will is it gets admitted to the court for probate. So I don't know why it's out there in the world. Of course, there's misinformation everywhere, but probate has its place. In Oregon, probate is not, it's not as bad as our neighboring states for their probate administration being expensive and lengthy. It's still a court process. It still has, some requirements that you have to fulfill. But a trust administration, like Jane said, it's much more efficient. It's a private administration. It's a lot more flexible in what happens.
okay. So what happens to the power of attorney when you die?
It dies with you.
Okay, that's good to know.
Yep.
So if you have a 401k or something that has a beneficiary, beneficiary named, does that have to be in the trust or will, or does it stay separate in your banking documents?
Yeah, so that's a really good question. So anytime you have in Oregon, this is not the same for some states like Washington, but in Oregon, the contractual beneficiary designation that you put on a retirement account, a life insurance policy, or even on an investment account or a bank account, wherever you can stick a beneficiary on something, in Oregon, that's going to take precedent over whatever you said in your will or trust. It never even hits your will or trust. It's going to go by what your beneficiary says.
Okay.
Specifically for retirement accounts, we want to keep those in your individual name because they've got all those tax qualified benefits to them. So they stay in your individual name, but then the beneficiary designation needs to be set up to match what your overall estate plan is.
Okay. Wow, so much great information today.
Good, good.
Yeah, it really is. Do you ever come over to Sun River to,
Yes.
well, I didn't mean for vacations, for working vacations?
Absolutely. Yes. Yeah, typically what I've been doing lately, and I'm sure most folks have done this, is that we've been doing more things by Zoom and more virtual, consultations with folks. And, but unfortunately, we still don't have the ability to do virtual signings. Some things we can do via e-notary or, DocuSign type programs, but the good old fashioned will signing still has to be in person. Even, within a window is okay. So, so Jane's there to help do signings. I've come over to do signings.
Okay, so just for people who signed in after we started, in the introduction, I mentioned that Sarah is affiliated with the law firm Watkinson Laird Rubenstein, and they have an office over in the business park in Sun River. The main office is in Eugene, correct?
Correct.
And the office in the business park, Jane Yates is in that office, and she lives up here, if I'm correct.
Yep.
And are you in the same building with the new Josie K's? And
I'm across the breezeway from her. So I'm right next to the dentist. I'm between the dentist and the folks who are doing all the aquarium and zoo design.
okay,
Yeah.
there you go. So the business park is not that big.
It's not. And there's a big sticker on the window that says WLR Law. So,
okay.
Yeah.
Thank you very much.
Sure.
And I want to thank you, Jane, because you reached out to me, gosh, maybe 6 months ago, and offered this opportunity to our community. And it's without people like you willing to help us connect, that's what makes Sun River U work. So thank you for reaching out and giving us this opportunity.
You're
Yeah, well,
welcome.
Gwen, thank you. It's one of those things that this is, a little bit of a job and a lot of a calling for me because, like I said, I do administration. So I see what happens when this doesn't go well. And if I can get in front of people to make it happen and make it go well, that makes my day. So I'm glad for everybody listening to pick up some nuggets about either getting their own planning in place or reaching out to others to get their planning in place, knowing that having to scramble last minute in emergency to get these fiduciaries, especially lifetime fiduciaries in place, it's not pretty, it's not cheap, and it's not fast.
Okay. Well, that just is it, an ounce of prevention, right?
There you go.
Pre-planning. Okay, we haven't had any other questions come in today, so we're going to say thank you very much. And for those of you who haven't signed on, Sun River U is offering 2 more classes in estate planning the next 2 weeks. They're always on Tuesday afternoons starting at 4, and we are using different experts in different categories for each of those. So go ahead and go to Eventbrite or the sunriveru.com website, look them up and sign up for more classes. So thank you. Thank you very much. And everybody enjoy the sunshine and think about your planning.
And fund your trusts.
And fund your trust. Well, thank you so much. And we're getting some feedback from people that saying excellent and great information. And so, and I'll share all the feedback. Remember, this has been recorded and it will be posted on YouTube Sun River U. And you can go back and re-listen. Take care, everybody.
Thank you.
Goodbye.